if you're on probation and you pick up a new charge or you violate probation, what's going to happen is your probation officer at some point is going to file a probation violation affidavit that gets filed with the court. If you were taken into custody, you will remain in custody and they will hold you no bond on the probation violation, even if you have a bond on the new case. And so there's increased pressure on you since you're in custody and you're being held without bond. Even if this was a minor offense, they will not let you out of jail because of the probation violation. And again, it puts a huge amount of pressure on you to now plead guilty to the new case that violated your probation in the first place. So that's why at all costs we try to avoid putting our clients on probation in the first place. The different standards of proof that the state have are, there's beyond a reasonable doubt, which is what we hear the most, what you hear on TV. That's the standard in the entire country, state and federal, for a criminal case. However, there are other standards that apply in different situations. For example, in a probation violation hearing, the standard is what's called preponderance of the evidence. That sounds like a very fancy and confusing word, but pretty simply just boils down to more likely than not. So judges use this example of the scales of justice, and if it tips even just ever so slightly, towards guilt, then that's a preponderance of the evidence. So in a probation violation hearing, for example, a judge only has to decide if he's 51% or 50.1% sure that you did it. That's all it takes. Whereas beyond a reasonable doubt, we can't quantify the number. We can't give you a percentage like we can with preponderance of the evidence, but it's a much, much higher standard.